When Claire Bennett signed the contract, she thought she was buying peace. Not luxury, not perfection, just peace. At 39, Claire had spent years rebuilding her life after a difficult divorce. She worked as a senior accountant in Charlotte, North Carolina, and lived in a modest 2-story house she had fought hard to keep. The kitchen was the last broken part of it. Warped cabinets, cracked tile, faulty wiring. She had saved for nearly 3 years to renovate it properly. That was why she hired Mason Klein. He looked trustworthy immediately. Clean truck, polished website, professional photos, confident voice. He walked through her kitchen with a tape measure and a calm certainty that made everything sound simple. 6 weeks, he said. Maybe 7 if materials are delayed, but you will have this done before summer. The contract looked professional. Demolition, electrical work, cabinets, flooring, labor. Total cost, $48.7. The payment schedule was tied to phases of the project. Claire signed that same day and transferred an $18 deposit. At first, everything felt right. Workers arrived early. Cabinets were torn out. The old tile was removed. The room became a construction zone, but it looked like progress. Mason texted often. "We are on schedule. Electrical crew tomorrow. This is going to look amazing." Then the second week came. The workers stopped showing up regularly. One afternoon, Claire came home to find the kitchen half demolished, exposed wiring hanging from the wall, and no one there. Mason answered only after several calls. "Supply issue," he said. "Nothing major. We are fine." The next day, no one came. A few days later, 2 unfamiliar workers showed up without Mason, worked for only a few hours, argued outside, and left. That night, Claire noticed a leak under a temporary plumbing line. By week 4, her kitchen was unusable. She washed dishes in her upstairs bathroom, ate takeout on the couch, stored groceries in a mini fridge, borrowed from her sister. Every time she called Mason, he had another explanation: a delayed supplier, an inspector rescheduling, a subcontractor emergency. "Claire, trust the process," he kept saying. By week 7, he asked for another payment. He said the custom cabinets were ready to ship, but only if he could pay the supplier that day. If not, he warned, she would lose the production slot and face another month of delay. Claire hesitated. Deep down, she already felt something was wrong. But she was tired, overwhelmed, and desperate to believe the project could still be saved. So she sent another $11.5. The cabinets never came. What came instead was silence. Mason stopped answering calls. His voicemail was full. His texts stopped. Claire drove to the business address listed on the contract and found an office suite with the company name already removed from the glass door. That was when panic turned into anger. She hired another contractor, Robert Hale, to inspect the damage. He spent less than 10 minutes in the gutted kitchen before telling her, "You need a lawyer before you need me." The problems were worse than she realized. Electrical work had been started, but not completed properly. Part of the subfloor had been too aggressively. One wall had been opened without proper support. Several materials listed in the contract had never even been ordered. The estimate to repair the damage and finish the kitchen correctly was more than $61. Claire had already paid nearly $30,000 for a kitchen she could not use. Now she would have to pay even more just to undo the damage. Her attorney, Evelyn Ross, filed suit in Mecklenburg County Superior Court. The claims included breach of contract, negligent construction, misrepresentation, and unfair or deceptive business practices. Then the case got worse for Mason. Evelyn discovered Claire was not the only customer with the same story. 2 former clients had already filed complaints with consumer authorities. One had paid for a bathroom remodel that stalled after demolition. Another said Mason demanded urgent extra payments for materials that were never delivered. A former employee gave a sworn statement saying the company often used deposits from new clients to cover old debts. That changed the case. This was no longer about one renovation gone wrong. It was about a pattern. Mason's defense was simple. He claimed the delays were normal. The project had become more complicated than expected, and Claire had grown impatient. His lawyer argued that renovation work is messy by nature, and that unhappy homeowners often exaggerate once costs increase. Evelyn didn't build her case around emotion. She built it around records, the signed contract, the payment history, the incomplete permit trail, the expert inspection, the supplier records. That last piece became the turning point. Because when Evelyn subpoenaed the cabinet supplier Mason had mentioned again and again, the record showed there had never been a paid order for Claire's cabinets, not delayed, not back-ordered, never placed. At deposition, Mason tried to soften it. He talked about informal discussions and unfinished measurements, but then Evelyn showed him one of his own messages to Claire. Payment sent, cabinets locked in, we're moving. She looked at him and asked, "When you sent that message, had you secured the cabinets?" "No," he admitted. "Had you paid the supplier?" "No." The room fell silent. At trial, Claire testified on the second day. She described weeks of living around construction dust, eating takeout, washing vegetables in her bathroom sink, and avoiding visitors because the center of her home looked like a disaster zone. Then Evelyn asked her, "What did this cost you beyond money?" Claire paused before answering, "It cost me the feeling that my home was mine." That was the moment the jury truly focused on her. Robert Hale, the replacement contractor, explained the technical damage. Then came Luis Ortega, Mason's former employee, calm but uncomfortable. He testified that new client deposits were often used to keep older projects from collapsing. Crews were sent out briefly just to create the impression of progress. When Evelyn asked whether Mason had ever spoken about Claire's case, Luis nodded. He said she'd already paid enough to keep things floating for a while. The defense attacked Luis as disgruntled and unreliable, but the financial record supported his timeline. New deposits matched old debts, supplier balances remained unpaid while new clients kept sending money. The pattern was clear. In closing, Mason's lawyer said this was just a business dispute, a renovation that became more expensive and more complicated than expected. Not every broken promise, he argued, is fraud. Evelyn stood and answered with precision. "This case is not about a contractor who tried and failed," she told the jury. "It is about a contractor who took money, made representations he knew were false, left a home unsafe, and used delay as a strategy." The jury deliberated for less than 5 hours. They found in Claire's favor. They awarded damages for breach of contract, repair costs, additional living expenses, and losses tied to Mason's misrepresentations. They also found that his conduct supported enhanced liability under the unfair and deceptive business practices claim, argued at trial. Mason did not look at Claire when the verdict was read. 3 months later, his company was dissolved. Claire's kitchen was eventually rebuilt, properly, safely, beautifully. But the real ending was not the tile, the cabinets, or the warm lights over the island. It was the fact that a courtroom had done what polished sales language never could. It forced the truth to finish what the contractor never did. Because this story was never just about construction. It was about what happens when someone sells certainty, takes trust as a deposit, and assumes delay will wear the victim down before justice can catch up. This time, it didn't. In the United States, a contractor who fails to perform may face more than customer frustration. A homeowner can bring a breach of contract claim when promised work is not completed, and damages are generally meant to place the injured party in the position they would have been in if the contract had been properly performed. Consumers are also repeatedly warned by the Federal Trade Commission to insist on written contracts, verify licensing and insurance, and treat pressure for large upfront payments as a serious red flag. In some situations, deceptive conduct can also create additional liability beyond an ordinary contract dispute. The deeper lesson is simple. A contract is not just paper. It is accountability in written form. And when someone takes your money, abandons the job, and hides behind excuses, the courtroom becomes the place where promises stop being marketing and start being evidence.